This is the Fletcher versus Peck case of 1810.
Hello, the video you're about to watch is a unique discovered broadcast of the events taking place during the Fletcher versus Peck Supreme Court case of 1810. This was one of the most influential Supreme Court cases in the United States history because it was the first time the Supreme Court shot down state law on constitutional grounds and established a precedent of John Marshall's strict interpretation of the Contract Clause.
John Peck, you are innocent.
That was the end. Now let's go back to the beginning.
The dispute over the case arose in 1795 when 3 Georgia legislators were bribed to grant 35 million acres of state land involving vast tracts of land to 4 independent land speculators in what is now Alabama and Mississippi to private speculators for a very cheap price per acre. One of these speculators was John Peck.
Where is he? Wait, what's going on? Don't worry about it.
I'll sell you these 13,000 acres of land to you for $3,000.
Sounds good. Wait, just to be sure, this land was granted to you legally, correct?
Yes, sir.
But little did they know that the Yazoo Land Act was passed through corrupt means, and when this was discovered, the state of Georgia tried to repeal the law because it was fraudulent, making the sale of the land void. This brought about some problems.
What the Peck? You promised me I'd have a good title over the land, but now the Yazoo Land Act has been repealed.
Okay then, we'll settle this in court.
Yeah, we will.
Question was whether or not the Act of 1796 was repealed was a violation of the U.S. Constitution's Contract Clause, which states, "No state pass any law impairing the obligation of contracts." If the act was deemed constitutional, then Fletcher would win the case, but if it was unconstitutional, then Peck would be innocent.
Order in the court. The case is Fletcher v. Peck in consideration of 15,000 acres of land sold by John Peck to Robert Fletcher for $3,000.
Your Honor, John Peck is guilty because he sold land to me that I was supposed to have title over, but now the Land Act has been voided, so I'm suing for damages.
In my defense, the state isn't even allowed to repeal the law because it is not in the state's power to nullify contracts.
Article 1, Section 10, Clause 1 of the Constitution states that government cannot permit ex post facto laws or laws that fix punishments for acts committed before a law was passed. Therefore, laws annulling contracts or grants made by previous legislative act are constitutional, impermissible, and unconstitutional. In this case, we find Peck to be an innocent third party who entered into 2 contracts. Number 1, where he bought the original land from the original grantee, and number 2, where he sold the land to Fletcher. This therefore places him out of the original fraud of the Yazoo Act of 1795. John Peck, you are innocent.
The reason for John Marshall's decision was, as he stated, when a law is in its nature a contract, when absolute rights have vested under that contract, a repeal of the law cannot divest those rights. This case was significant because it was the first to establish power of the Supreme Court over the state legislature, and the decision remained as a barrier to state economic regulations of business corporations until in 1837 in the Charles River Bridge versus Williams Bridge case, where the issue of contract clause was reopened.